This podcast is brought to you by the School of Advanced Study, University of London.
Thank you very much for inviting me to participate in this very interesting conference. You will have gathered from Patricia's very kind introduction that I'm not an academic and that my professional life has been largely in the criminal law, mainly in the magistrates' courts. Beyond that rather narrow field, I do not feel competent to meet the challenges of today's subject, but I hope you will forgive me if I attempt to address the principle of the points that are being raised from the point of view of summary justice. May I take you back to 1361? Keith will remember it. England was at that time in the midst of the 100 Years' War, and it had just suffered the most appalling losses through the Black Death, and against that background, crime and disorder was growing rapidly. As a result, Parliament decreed in the Statute of Westminster that every county shall be assigned, for the purpose of keeping the peace, one lord, 3 or 4 of the most worthy in the county, with some learned in the law, and that they should all have the power to restrain offenders, rioters, and all others exciters of quarrels, and cause them to be imprisoned or duly punished according to the law and customs of the realm. And it was those county worthies who came to become the justices of the peace that have been the cornerstone of our summary justice in England and Wales for over 750 years. But it was not just in England and Wales, and between the 16th and in the 17th and 18th centuries, the role of Justice of the Peace travelled from England across the empire, carrying what many of us would regard as the lasting legacy of the rule of law, the common law, and judicial independence. If I have one moment to go off on a tangent, I was at a dinner party some months ago, which until that moment was a very pleasant one, and I was then asked, when was it that judges gained independence? And I must admit, it did make me scratch my head. Was it Magna Carta, 1215, Bill of Rights, 1689, Act of Settlement, 1701? In the end, I had to admit that I did not know. As a result, my host went and Googled it. And what date do you think he came back with? 2005. Because it was the Constitutional Reform Act which removed the Lord Chancellor, who was then part of the legislature and part of the executive, as the chief of the head of the judiciary. So only then did we gain this independence that we've been regarded so important. Not important for the judges, but important for the public who come to the courts expecting to get an independent decision. So the Founding Fathers travelled off to North America in 1600s, and they appointed from their number justices of the peace and carried out certain administrative duties as well, but carried out particularly the judicial functions of summary justice. And indeed, I understand that the first courts were held in the very boats that they had travelled in, the ships that they'd travelled in North America in. Their influence and that of the common law spread throughout the colonies, and they continued to flourish. And they did so and continued to flourish until the War of Independence. What Lord Judge has pointed out to us was in fact a civil war between the British. But at that point, clearly the historical connections with England became an embarrassment, and the future of justices of the peace in North America waned. But the 150 years that they had to influence things were enough to establish the principles of common law still present in North America. The settler population, where it was in the majority, and there was little else there, was able to introduce the common law immediately. If the new population was not predominantly settler, but included indigenous populations, the law of the traditional and customary courts was incorporated in the common law where it was not inconsistent. Where the settler population was in the minority, traditional and customary courts continued in the hands of elders and tribal chiefs, with the courts administered by the justices of the peace having a concurrent jurisdiction. Leaving the British Empire for a moment, or only partly leaving it, because it's always already been mentioned, Rwanda is an interesting example. Formerly a Belgian and German, part of the Belgian-German Empire, it is now part of the Commonwealth and is changing from civil law to common law. But there they, of course, had the ordeal of that terrible genocide 20 years ago. And the way they dealt with it was really quite remarkable. The serious offenders were prosecuted locally, where it was some doubt as to whether or not they could achieve an independent jurisdiction. They created the Rwanda tribunals to deal with them. Subsequently, the local courts have been dealing with them, but they also set up their gacha customary courts on a truth and reconciliation basis similar to that in South Africa. By all accounts, it had a remarkable success. But the prosecutions still continue, and there is at the present time in my old court in Westminster an extradition case involving what is alleged to be some of the leaders of the Rwandan genocide being prosecuted with a view to returning them to Rwanda for trial. Also, I think significantly, and certainly significantly for many African countries, was that Rwanda, that had been through such an ordeal, did abolish the death penalty. And the Chief Justice of Rwanda commented that we've killed 1 million, we're not going to kill any more. However, as a slight aside, we move back to England, where the JPs were in full flood, and in 1788 were using their powers of transportation. The prisons were full, as they are now, so in 1788, 759 convicts set off for New South Wales, and they were accompanied by a battalion of Marines. Their commanding officer became the governor, and the senior officers were appointed JPs, and they immediately applied the common law in courts of summary justice on arrival. But back in England, a little later on, the JPs were flourishing, except in one place, and that was London. Because at the end of the 17th century, justices of the peace had become corrupt. They were known as the trading or basket justices, and they required payment for their decisions. The basket involved either a basket of goods brought to them by way of payment, or indeed the more blatant ones actually left the basket at the door for it to be filled as people came in. So as a result of that, the justices of the peace were temporarily suspended. I say temporarily because in the scheme of things, in the length of English judicial history, 230 years is perhaps not very long, but 230 years it was, because from 1735 until 1965, the Justices of Peace did not operate in the criminal jurisdiction in London. They returned in 1965. But in 1735, Sir Thomas de Vale started as the first magistrate in London, and he bought a house in Bow Street, used the front room as his court. He used hue and cry and a posse of men to go out each evening, and he went out with them, made the arrests. They deposited the felons in the bare public house in their cellars, and the next day he tried them. It had the advantage of a lot of evidence was unnecessary, because he knew. But quite a remarkable man. He was followed by the two Fielding brothers, and Henry Fielding, of course, the author, and his half-brother, Blind Jack, because he was blind. He conducted the court in Bow Street and recognised all the local villains by their voices. Those events in 18th century London may have been purely coincidental, but as Sir Thomas Skirm in his seminal work on Justices of the Peace notes, in most of the countries into which the JP system was introduced, the justices gradually became discredited, and there has become a clear move away from lay, unpaid, honorary magistrates towards a professional judiciary. But England and Wales maintains a strong and influential magistracy of some 25,000 JPs, very dedicated and hard-working, and 150 district judges provide a complementary role on criminal and civil justice, on summary justice. If I may turn now briefly to the recent evolution within England and Wales. In the last 30 years, there's been separation from the local authorities. They're no longer responsible for providing accommodation for the courts. Now rests with the court service. All the administration is done through the court service itself without any employees of the local authority. The courts are now less busy, but have got less courtrooms to occupy because of court closures. There has been a clear move for diversion of cases out of the courts. If you had wandered into Bow Street 30 years ago, the first hour of the morning, you would have seen 30 cases pass through the courtroom of drunks and prostitutes. It was a really fast-moving and quite exciting to do, I can tell you, to get through those defendants, giving them all the opportunity to say something. Fortunately, they've all been trained to say nothing, and getting through all that work. Now you don't see any of that. They are all dealt with by diversions, by fixed penalties, by penalty notices, cautioning and reparation, particularly for youths. The youth court has far less work than it used to have because of this. There is a worrying element to it in as much as the police have the power and the decision to make, to decide whether cases should come to court or whether they're going to deal with them by way of reparation, and if so, how, and indeed for what offences. It's not just minor offences, it can be quite serious ones. And there is a concern that the police are acting both as police, judge and jury, I believe that there are now steps to try to see that this is properly monitored. We're now into professional training of justices. The Sentencing Council is providing guidance on sentencing, and the criminal procedure rules, which we've already heard about, are now fully in force. The old days of advocates regarding a case as a game of cricket is no longer permitted. Everybody must disclose their positions, and the cases, one hopes, are then properly presented and properly prepared. Part of the difficulty about preparing has been the fact that the Crown Prosecution Service is underfunded. They have moved to technology, as indeed have the courts, but they have moved to technology in the form of all their cases are going onto tablets. And so they come into court now clutching an iPad and hope to be able to address you as to all the facts of the case and provide you with details of previous convictions, all off an iPad. It's not working very well. If I've got one moment just to digress again and say that once, while I was at Bow Street, we used to have a number of visitors, and on one occasion I had colleagues come to visit, one from Belfast, Northern Ireland, one from the British Virgin Islands, and one from Brisbane. And I decided we all really ought to go out to lunch. I'd had a particularly bad day getting to court that day. Southwest trains had let me down. It was crowded and late and disastrous. I moaned a bit about this over lunch. "Oh," said the man from Brisbane, "that's funny. He said, I run along the bay. He said, I have a swim and I get to court, have a shower, and I'm ready to go." "Oh, that's fine. What do you do?" I said to the British Virgin man. He said, well, I go to a different place each day. So on Mondays, he said, I walk to court. But Tuesdays, Wednesdays, Thursdays and Fridays, he said, I sail in my boat to the island wherever I'm supposed to be going. So that sounds very nice. And then my colleague from Northern Ireland pipes up and says, yes, he said, I wait for my armoured car. Thank you.